Judge Edward Keel, nominated to the District of New Jersey. I'm sorry if I mispronounced that name. Is that correct? Thank you. Sarah Russell, nominated to the District of Connecticut, and Christopher Fonzone, nominated to be an Assistant Attorney General in the Justice Department's Office of Legal Counsel. I congratulate all the nominees and the families and friends supporting them here today. We have several colleagues joining us today to introduce today's nominees, and I will introduce Mr. Fonzone personally. But first, I'll turn to Senator Graham for opening remarks.
Thank you, Mr. Chairman. I think tomorrow we'll be taking up subpoena request. None of us will support that, and Senator Grassley and I are working on some subpoenas of our own. So if you want a subpoena war, you'll get one. I can't believe we're doing it in the middle of all this stuff, but there you go. Thanks.
Thank you, Senator. We'll hear introductions of our nominees. First is Senator Shaheen to introduce Mr. Aframe.
Thank you, Chairman Durbin, Ranking Member Graham, Senators Grassley and Whitehouse. Thank you for this opportunity to introduce Seth Aframe, who is nominated to serve as a judge on the First Circuit Court of Appeals. Mr. Aframe is joined today by many proud family members who are sitting with him, his wife Karen, his sons Max and Noah. He's also joined by his parents, Lisa and Jeff, his brother Craig, and his in-laws, Ellie and Ed Sondick. Thank you all for being here. Mr. Aframe is an impeccably credentialed and highly respected member of the New Hampshire Bar. He is a graduate of Georgetown University Law School and has spent most of his legal career in public service. Since 2007, Mr. Aframe has worked as an assistant United States attorney in the New Hampshire United States Attorney's Office, where he currently serves. He is chief of the criminal division and chief of the appellate division. He's tried 20 cases in federal court and argued more than 100 appeals before the First Circuit. He has more appellate experience than almost any attorney in New Hampshire. And it speaks volumes that all four former U.S. attorneys whom Mr. Aframe has served under, appointed by both Republican and Democratic presidents, are supporting his nomination. In a joint letter, these former U.S. attorneys say of Mr. Aframe, and I'm quoting here, "Each of us regards Mr. Aframe as a distinguished and persuasive appellate advocate who has successfully represented the government and earned a well-deserved reputation for excellence. His knowledge of the law is extensive, his writing is pristine and persuasive. We doubt there is any practicing attorney who has briefed and argued more cases before the First Circuit," end quote. But the praise is not just from prosecutors. A group of defense attorneys who have litigated many times against Mr. Aframe have also lauded his nomination. Again, I'm quoting, "We believe Seth has a perfect judicial temperament. In what is often a difficult role as a prosecutor, he epitomizes open-mindedness, courtesy, patience, freedom from bias, and commitment to equal justice under the law," end quote. Moreover, the ABA echoed these glowing endorsements in giving Mr. Aframe a unanimous, well-qualified rating. Outside of the courtroom, Mr. Aframe is an adjunct professor at the University of New Hampshire Franklin Pierce School of Law, demonstrating his steadfast commitment to sharing his legal expertise and the benefit of his robust appellate and criminal experience with attorneys of tomorrow. Above all else, it is abundantly clear to all who know him and have worked with him that Mr. Aframe's intellect and his commitment to preserving justice and integrity in the law make him an excellent candidate to serve on the federal bench. His nomination is also supported by the former president of the New Hampshire Association of Criminal Defense Lawyers and past presidents of the New Hampshire Bar Association, among others. In reflecting on their time working with Mr. Aframe, his former colleagues at the U.S. Attorney's Office said, quoting again, "His knowledge of the law is deep and extensive. During our time working with Mr. Aframe, there is no other person who was relied upon more to clarify complex legal issues, provide sound and thoughtful advice on legal strategies, and to aid in providing the best representation of the United States." Mr. Chairman, Ranking Member Graham, Senators, I believe that Mr. Aframe's deep appellate experience, his unwavering commitment to equal justice under the law, would make him an excellent judge. Thank you again for allowing me to introduce him today. I'm honored to be here, and I urge the committee to support his nomination.
Thank you, Senator Shaheen. And I might just say for the record that visiting senators who are issuing endorsements are not expected to stay. We know you have busy schedules. You're welcome to stay as long as you'd like to. Senator Hassan.
Well, thank you, Senator Shaheen, and thank you, Mr. Chair and Ranking Member Graham, and distinguished members of this committee. I'm honored to be here to join Senator Shaheen in introducing Seth Aframe of Hopkinton, New Hampshire, to the committee. And I am pleased to join Senator Shaheen and other New Hampshire leaders in supporting Mr. Aframe's nomination to serve as judge on the United States Court of Appeals for the First Circuit. I also want to thank Mr. Aframe's family for being here today. I know how proud they are of him and how proud he is of them. As you heard from Senator Shaheen, Mr. Aframe is exceptionally qualified to serve on the First Circuit Court of Appeals. The American Bar Association unanimously rated him as well qualified, the highest possible rating, and at every step of his career, Mr. Aframe has demonstrated professional excellence. Granite Staters know that they can always depend on Mr. Aframe to pursue justice, exercise fairness, and do right by the people of New Hampshire. Mr. Aframe's work in the U.S. Attorney's Office includes arguing many cases before the First Circuit, leading the appellate and criminal divisions, and working on the Laser Docket, a drug court that helps get people struggling with addiction into treatment. His exemplary service in the U.S. Attorney's Office is matched by his dedication to his community. He has taught at the University of New Hampshire's Law School for 15 years. He regularly gives back to the next generation of aspiring lawyers by serving as a judge for student mock trials. He has served both as a member of his local school board and as president of his synagogue, Temple Beth Jacob. In this way, Mr. Aframe demonstrates the New Hampshire ethos of all hands on deck. That's our approach to service. And Mr. Aframe has demonstrated that approach in serving his community, his state, and his country. It is therefore no surprise that many Granite Staters have come forward to strongly endorse Mr. Aframe's nomination to the First Circuit. 4 previous United States attorneys for the District of New Hampshire wrote a letter stating, quote, "Each of us regards Mr. Aframe as a distinguished and persuasive appellate advocate who successfully represented the government and earned a well-deserved reputation for excellence." It's not only Mr. Aframe's fellow prosecutors who have confidence in his abilities. New Hampshire defense attorneys, including public defenders, also trust and support Mr. Aframe. Charles J. Keefe, writing a letter on behalf of these defense attorneys, wrote that in what is often a difficult role as prosecutor, he epitomizes open-mindedness, courtesy, patience, freedom from bias, and commitment to equal justice under the law. Mr. Aframe also has the backing of many New Hampshire law enforcement officers, including one letter that highlighted how, quote, "We have observed firsthand Seth's professionalism and unmatched abilities as a federal prosecutor. His honesty, straightforward demeanor, and overall compassion for people have distinguished him in that role." Additionally, past presidents of the New Hampshire Bar Association strongly support Mr. Aframe. The breadth of support from both sides of the courtroom, from the legal community and law enforcement alike, is a testament to Mr. Aframe's exemplary career thus far. He is exactly the sort of person our country needs on the judicial bench. I have no doubt that as a judge on the First Circuit Court of Appeals, he will serve with the same excellence, selflessness, and commitment to his state and country that has defined his entire life. And he will make every Granite Stater proud. Thank you.
Thank you, Senator Hassan. And at this point, Senator Menendez is recognized.
Thank you, Mr. Chairman, Ranking Member Graham, distinguished members of the committee. Today I have the pleasure of joining Senator Booker in introducing another exceptionally well-qualified nominee for the U.S. District Court of New Jersey, Mr. Edward Sun Keel. If confirmed, Mr. Keel would be ready to serve on day one. He already knows the District of New Jersey and the Newark Courthouse. After all, it's where he has capably served as a U.S. magistrate judge for the past 4 years. In every case and at every step, he's demonstrated an even temperament and a resolute commitment to equal justice under the law. During his time on the bench, he has shown a keen intellect and a deep reverence for precedent and the rule of law. In addition to his regular duties, Judge Keel serves as Newark's Visitage's pretrial opportunity program, an initiative that offers treatment alternatives and non-custodial sentences for eligible individuals. Before his dedicated judicial service, Judge Keel spent 27 years as an attorney in the Garden State, developing an extensive record, including a pro bono work for numerous organizations as well as several church groups. He has sterling credentials and a wealth of accumulated trial experience. But beyond these qualifications, I would submit to my colleagues that what makes Judge Keel an ideal candidate for the federal bench is his lived experience. Judge Keel was born in Daegu, South Korea, to parents who fled North Korea on foot during the war. To hear him tell his story, his parents didn't have much in the form of material possessions, but nonetheless they considered themselves rich. Guided by unwavering faith, they set out towards uncertain shores in America with just $40 to their name, a gift pooled together by relatives before the journey. On their very first Sunday in the United States, Judge Keel's mother, who is here with us today, placed the money in the church's offering plate. What an amazing story of resilience and optimism. What a powerful testament to the American dream. When Judge Keel's parents became U.S. citizens in the late 70s, they did so in the very courthouse where he now serves as magistrate judge. Both of his parents' naturalization certificates hang in his chambers as a reminder of what is possible in this country we all love. So make no mistake, Judge Keel is eminently qualified to serve as a U.S. district judge. He has the temperament, the knowledge, and the integrity that we look for in judicial nominees. As I've long believed, our independent judiciary must reflect the best of America, the best of our citizens, and the best of our values. With his experience and his perspective, Judge Keel is both. His nomination not only addresses our shared goal of filling judicial vacancies, it also ensures that our sacred institutions better reflect the rich tapestry of our nation. It is therefore my hope that Judge Keel earns strong bipartisan support from this esteemed committee so that he can swiftly be confirmed to the District Court of New Jersey. I have no doubt that he will be an incredible legal asset to New Jersey's federal bench, and I encourage my colleagues to give him all the due consideration at today's hearing.
Thank you, Senator Menendez. Senator Booker?
I truly appreciate joining with Senator Menendez in really celebrating an extraordinary American. Judge Keel, who's with us right now, is someone that should make our whole nation celebrate. He's joined here by his mother, Gracie, his wife for 25 years, Nancy, and his 3 children, Elizabeth, Amanda, and Andrew. Good to see them all here. He's joined by his brother and sister-in-law and members of his judicial chambers. This is extraordinary to have this gathering of New Jerseyans here to witness something that is truly special. As Senator Menendez says, Judge Keel was born in South Korea. His mother and late father escaped tyranny in North Korea, and they did that during the Korean War. Judge Keel's family ultimately settled in New Jersey, where his father founded New Jersey's second oldest Korean church, the Korean United Presbyterian Church in Bloomfield, New Jersey. And his mother worked as a dry cleaner, in the dry cleaners to support the family. Together, Judge Keel's parents built a life in New Jersey motivated by faith, a desire to serve community, and a love of country, fealty to this nation, faith, and family. There's nothing more American than that trifecta. And their sacrifice and their love raised a man who is, in many ways, as James Baldwin said, children are never good at listening to their elders, but they never fail to imitate them. Judge Keel's nomination is momentous, and here's the really magic of it. It is a full circle realization of the American dream. I hope my committee members listen to this. Should we confirm him as a federal judge, he will serve in the same courthouse where his parents were naturalized as citizens of this great country. Judge Keel's confirmation will bring us so much closer to ensuring that our judiciary is truly reflective of the rich tapestry of experiences of all Americans. It has been a privilege of mine to get to know this family. They have moved me and inspired me. And Judge Keel now is a fixture in our nation and in our state. Again, in that trifecta, he's a fixture as a faith leader. He's a fixture as a family man. And he is a mentor to so many great young attorneys, many of them who are here right now. It is amazing that Judge Keel is someone who would be a great leader in and of himself, but would be a trailblazer in his position as a Korean American federal judge in our state. There are many, many obligations as a United States Senator, but perhaps none is more exciting than to be able to be a small part of the ascendancy to the judiciary of such extraordinary Americans as this one. His experience serving the people of New Jersey as a magistrate judge on the District Court of the District of New Jersey, presiding over civil and criminal cases. His experience is clear. He has issued more than 1,000 orders, reports, and recommendations and opinions. He's volunteered to preside over the court's pretrial opportunity program, something very important to me and many other members here, a front-end diversionary program for nonviolent offenders caught up in the criminal justice system. He is living those ideals in the faith he believes in. May justice roll down like water and righteousness like a mighty stream. We are blessed to have him before us today, and I am excited about his testimony and, more importantly, about his ascendancy to the federal judgeship. I believe in the grand story of America. This is truly one of the great family journeys, and I'm excited to have him here today. Thank you.
Thank you, Senator Booker. I now recognize Senator Blumenthal.
Thank you, Mr. Chairman. Thanks for holding the hearing, and thanks to President Biden for nominating this extraordinary group of lawyers and people with such broad and impressive experience to the federal bench. I'm very honored to support Sarah Russell, a nominee for the District of Connecticut Federal Court. Senator Murphy and I were privileged to suggest her to President Biden, and we thank him for moving forward, and this committee, Chairman Durbin and Ranking Member Graham, for having this hearing today. I can't really say too much in favor of Sarah Russell. She is what we litigators would call the real deal. She has the intellect, but more than just the book smart learning and academic qualifications, she has the emotional intelligence to be a truly great judge. The caring and compassion combined with toughness, which is required of a judge, and the experience of not just teaching and litigating, but actually combining the two. She has taught students how to litigate. And I have personal experience in knowing of her work as a litigator in the federal courts. She graduated from Yale as an undergraduate and then Yale Law School. She clerked for two extraordinary federal judges, one district court judge and the other a court of appeals judge. And then she began an extensive and impressive career in the courts, which has won her praise from prosecutors, from academics, from everybody in the Yale and Connecticut legal community. A group of 16 former federal prosecutors has written on her behalf, and a former chief of the Office of the Criminal Division in the United States Attorney's Office, Connecticut's Inspector General, Robert Devlin, a former federal judge, Brian Austin, former senior state's attorney, Kevin Kane, former chief state's attorney, Maura Crossan, who is the victim's advocate. Prosecutors respect her work as much as the defense bar. And I want to quote one letter In particular, by the way, Mr. Chairman, I'd like all these letters to be made part of the record if there's no objection.
Without objection.
One letter in particular from Robert Devlin, his concluding paragraph. This is from a former prosecutor and a judge. I always found Sarah Russell to be even-handed in her approach to issues. It goes without saying that she is a person of towering intellect and unquestioned integrity. As a judge, I have no doubt that she would demonstrate great fidelity to the rule of law. She is also unpretentious and quite likable. She would make an excellent federal judge. I would just conclude by saying her fidelity to the rule of law is perhaps her singularly most important qualification at a time when the rule of law is threatened as never before. We need judges like Sarah Russell. I'm very pleased to support her today. Thank you, Mr. Chairman.
Thank you, Senator Blumenthal. Now I am pleased to introduce Mr. Christopher Fonzone, nominated to be an Assistant Attorney General in the Justice Department, Office of Legal Counsel. Born in Allentown, Pennsylvania, received his undergraduate degree from Cornell, his JD from Harvard Law School. He then embarked on 2 extraordinary clerkships. He clerked first for Judge J. Harvey Wilkinson on the Fourth Circuit Court of Appeals, and then for Justice Stephen Breyer on the United States Supreme Court. Mr. Fonzone has a significant amount of experience in federal government, including the Department of Justice. Began his legal career as an attorney with appellate staff in the Department's Civil Division, also served as attorney advisor with the Office of Legal Counsel, 2 years as special counsel in the Office of General Counsel at the Department of Defense. For 4 years, from 2013 to 2017, he held several roles in the White House, including service as counsel in the White House Counsel's Office and legal advisor to the National Security Council. After leaving the White House, he spent 2 years as member of the Fulbright Foreign Scholarship Fund at the State Department, completed a stint in private practice advising clients on privacy and cybersecurity before returning to public service. In 2021, President Biden nominated him to serve as general counsel to the Office of Director of National Intelligence, confirmed by the Senate on a bipartisan basis for that job. An impressive dedication to public service. I look forward to hearing more about his breadth of experience. Congratulations, Mr. Fonzone, to your family and friends who have gathered here today. Before we move to the first panel with Mr. A-Frame, I've been asked to recognize my colleague, Senator Whitehouse.
Thank you very much, Chairman, and hope my colleagues will indulge me for 1 second because I have long pending business with the Department of Justice that I need to bring to resolution, and I hope very much that that resolution can be achieved before a committee vote on Mr. Fonzone, and certainly before a floor vote, so there is no delay in getting him into the Office of Legal Counsel. But for my colleagues' benefit, I want to explain why it has come to this. Back in the Obama administration, I asked Attorney General Lynch to take a look at whether the successful DOJ civil RICO case against the tobacco industry for fraudulently misrepresenting the dangers of its product was a template for litigation against the fossil fuel industry. After considerable prompting, I ultimately received this letter from the Department of Justice, FBI, which told me 2 things. 1, be assured this referral was taken seriously and was thoroughly assessed. 2nd, the government must prove beyond a reasonable doubt the existence of an illegal enterprise. For those in the room who aren't lawyers, this was a civil RICO case, and beyond a reasonable doubt is a criminal burden of proof. And if you actually went and looked at the tobacco complaint the DOJ brought, it actually pled the burden of proof. So clearly, whoever wrote this letter had not even bothered to read the complaint. So I take no solace in the assertion that this referral was taken seriously or was thoroughly assessed. 8 years later, there's still no evident sign of an honest look having been taken. 8 years. The FBI's supplemental background investigation into Brett Kavanaugh after the sexual assault allegations surfaced during his confirmation process seemed to violate DOJ and FBI policies, and false things seemed to have been said about it. So I've pressed to understand what actually went on. During the time that the FBI virtually opened its files to committee Republicans to investigate the Crossfire Hurricane investigation, literally box loads of documents, I was refused any information, including things as simple as the FBI's public tip line policy guidelines. We found it on the internet. Materials eventually gradually dribbled out, but very slowly. No claim of privilege, just stalls and non-cooperation. That has now been a 5-year wait, and I would like to get this matter resolved. Then in the Trump administration, the Antitrust Division sent a threatening letter to auto companies that had embarrassed the White House by concluding emissions negotiations with the state of California that the fossil fuel industry didn't like. I'm not a great antitrust expert, but I do know that when corporate interests gather to lobby governments, that is exempt from antitrust, the Noah-Pennington doctrine. So I wanted to know what had prompted the letter. I was asked to stand back while the Inspector General investigated. I was told because of the ongoing review by the Office of Inspector General, the department has not endeavored to answer your specific questions concerning the matter, as we believe it is appropriate to wait until OIG completes its review to respond to any questions you then may have. There is no ongoing Inspector General exemption to congressional oversight, and it has now been 3 years. I asked both of those letters be made a part of the record.
Without objection.
And finally, an FBI agent who worked in the New York field office during the Clinton, Comey, Giuliani FBI New York field office fiasco has been charged with crimes. In his plea negotiations, I wanted to make sure he was questioned independently, like by the Inspector General, about that fiasco. The FBI has every incentive to cover up that fiasco, so an independent debrief as a condition of the plea seemed an obvious precaution. I can't get an answer about whether the IG is involved. Remember, in the letter I just read, I was told that the IG was involved and that that was the reason why I couldn't get any information. Here I'm told that they can't tell me if the IG is involved. It seems to me that DOJ either can or cannot tell me about IG involvement, but it doesn't get to do both. That's been only about a year, but it's a really easy question. And it's a pretty important one when you consider the incentive of the FBI not to expose whatever happened between the New York field office and former U.S. Attorney Rudy Giuliani and Director Jim Comey that caused Director Comey to violate DOJ procedures and launch political torpedoes at Hillary Clinton. So again, my apologies to my colleagues for taking this time, but I did want to explain, because I really don't do this often, what has come to this point, and I hope it will be resolved before votes come on Mr. Fonzone, who is well qualified for his position and had no role in any of these problems.
Thank you, Senator Whitehouse. The first panel is Mr. Seth A. Frame, and I ask him to please remain standing for a moment to take the oath. Do you affirm the testimony you're about to give before this committee be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Senator.
The record reflect the witness and nominee have answered in the affirmative, and you may proceed with the opening statement.
Thank you, Senator Durbin. Thank you, Ranking Member Graham and members of the committee. First, let me thank the committee for holding this hearing today. And second, thank you to the President for nominating me to this important position. And finally, thank yous to Senator Shaheen and Hassan for those kind introductions. At the outset, please indulge me to mention an experience that actually may not be referenced in your materials. From early on, I was interested in American government, which merged into my interest in the law. My earliest formative experience was in the fall of 1990, when as a junior in high school, I came here as a United States Senate page. And in fact, Senator Grassley was already about 10 years into his tenure. That semester, I developed a conviction which has never left me to pursue a career in public service. I never thought I would speak to a committee of United States senators, and I cannot pass on the chance to thank you for the PAGE program. As it did for me, I know it has turned hundreds of other young people toward careers in public service. Let me turn now to a critical figure in my life, Judge Jeffrey Howard. In 2003, my wife and I came to New Hampshire from Boston for a year. I intended to clerk for Judge Howard and then find a career in public service back in Boston. We fell in love with the Granite State that year, and Judge Howard graciously extended my clerkship until I could find the career I wanted in New Hampshire. I hope I will get to discuss later all that I learned from Judge Howard about being a good person, a good lawyer, and the attributes of a good judge. But for now, I want to thank him for allowing me to pursue the career I wanted in the place that I love. In 2007, I found that career when I joined the United States Attorney's Office. It has been an honor to represent the United States in the District Court in over 100 times before the First Circuit Court of Appeals. I want to thank all the United States attorneys, Tom Colantuno, John Kakavas, Don Feith, Emily Rice, Scott Murray, John Farley, and Jane Young for giving me so many opportunities. Mr. Chairman, New Hampshire has been a great place to be a lawyer. I've learned so much from opposing counsel, law enforcement, U.S. attorney colleagues, court staff, and the judges before whom I appeared. I am grateful to all of them. And now let me introduce you to my family. I am thankful to have my parents and in-laws here today. To my parents, Lisa and Jeff, what can I say? You have loved me every day and done everything you could to make every dream of mine come true. And I am lucky to have the greatest in-laws, Ellie and Ed Sondick. They have loved me like their own sons shortly after I stepped foot in their home almost a quarter century ago. I'm fortunate to have my brother Craig here, not only a sibling, but a good friend, and I am pleased that his family is watching in Massachusetts, and then my brother-in-law Rob and his family are watching in California. And now let me introduce my two terrific sons, Noah and Max. Noah is a junior in Hopkinton High School. He wanted me to thank the committee for holding the hearing in the brief interregnum between varsity soccer and basketball seasons. Max is a sophomore at Tufts. I asked him what class he would miss today. He told me American politics, but he said that traveling to D.C. for his dad's Senate confirmation was a pretty good excuse for that class. And finally, Karen, my wife of almost 22 years, she is the best thing that ever happened to me. She is my best buddy. Life has been great because of her. I also have two colleagues I'd like to recognize. Retired AUSA Arnie Huftelen is one of my great mentors, and AUSA Georgie McDonald is my great friend and frequent trial partner extraordinaire. I have several other friends and colleagues in the room and many more watching at home. Thank you to all of them. Mr. Chairman, I have worked for or practiced in front of the First Circuit for most of my career. To possibly continue my career in public service by joining that court brings me great joy. To do so by assuming Judge Howard's seat, representing the state I love, places that joy beyond words. Thank you so much. I look forward to answering your questions.
Thank you, Mr. Aframe. There are so many aspects of your career that I could speak to, but I want to raise a question about something that you've identified as an important part of that career. We ask you to identify the cases you've been involved in that you wanted us to take note of. And the fifth case is one entitled United States versus Smith. In that case, you represented the United States prosecuting at trial, on appeal, and in post-appeal litigation. It involved a defendant who had produced child pornography images by raping a 3-year-old girl and capturing the encounter on video. The defendant was ultimately convicted and sentenced to 600 months of imprisonment. The conviction and sentence were affirmed on appeal. The reason I raise this case is because of a note that you've included in describing the case. And you said, an important part of the trial preparation was helping the victim's parents deal with feelings of guilt and allowing the defendant access to their daughter. The reason I raise that is this has been an issue which we've considered in this committee, something known as CSAM, child sexual abuse. It is an outrageous situation, horrible, and has impacts on children which go far beyond the obvious. And it appears this case that you represented the government in at least touched on that same concern that we all share. We passed a bill out of this committee unanimously to deal with the people in big tech and their response to try to protect our children. As a parent and grandparent, I live in fear of this little piece of technology. And when I see my grandchildren holding on to it and dealing with it every minute of every day, I wonder what's happening. Even the most conscientious parent cannot be sure that they're protecting their child. Would you comment on that particular note that you made in that description of the case?
Yes, so Senator, as you've sort of described the facts, it was a very difficult case. It was a young child. The defendant had ingratiated himself to the family to get access to the child, and so of course the family when it came to light what the defendant had done with this child, felt tremendous guilt. And so obviously prosecuting it in the traditional sense was an important part of that case, but it was a very important part of that case to work with the family, to console the family, to help the family understand that it was not their fault, and to help the family see that the criminal justice system can do only so much. We can do what we did, which is prosecute and put the defendant in jail, but ultimately this child was young and the family was going to have to, figure out how to move forward. And I think part of that case that I am most proud of, I think, is that I was able to help them sort of change that mindset from guilt to figuring out how are they going to move forward when the criminal justice system part of the case was over.
Thank you very much. Senator Graham?
Thank you. In that case, I think you recommended 60 years, is that right?
Yes, I believe so.
Why not life?
Those, I believe, were the guideline, beyond the guideline. I think it was consecutive sentences on multiple counts. I believe production of child pornography carries 30-year maximums, so I believe we couldn't have asked for life based on the statutes.
All right. Are you familiar with the Carpentino case?
I am, Senator.
Okay. This involves a man who is accused and convicted of raping a disabled 14-year-old who is deaf, I believe. Does that ring a bell?
Not deaf, but hearing impaired,
Hearing
certainly.
impaired. But disabled, right? 14-year-old?
14-year-old, hearing impaired.
And the person that raped her had previously served 13 years for sexually abusing other minors. Is that correct?
I don't know if it was 13 years. I take your word he did serve a prior sentence for a state sex offense.
Against minors?
I believe so.
Okay. And you recommended 405 months. Is that correct?
I believe so, and I think the judge sentenced him slightly lower than that.
Yeah. Okay. There's a note in a memo here. The sentence requested here will incapacitate the defendant until he is in his 60s. Hopefully by that time, the danger the defendant presents will have subsided. Did you write that?
Either I or my colleague did.
Well, it was given under your name, your office.
I understand what you're...
Is it your testimony before this committee that you age out in terms of being a sexual predator against children?
I think that certainly that there's an argument that as you get older in age, that's possible. That was certainly a guideline sentence that we requested in that case, which is a very long sentence.
What information did you have to suggest that was possible?
Look, it is challenging to predict what's going to happen to someone 405
Don't you think the past is the best indication of the future? The man was served 13 years in jail, got out, raped a 14-year-old girl, and you believe that if he got to his 60s, it'd probably be okay.
And he received a very long sentence.
Well, the point is, can you give me information about some source that says that over time your propensity to do this to children goes down?
I think there's some evidence that...
Thank you very much.
Senator Whitehouse?
Welcome, Mr. Ephraim.
Thank you, Senator.
Good to have you here. I wish you well in your travels to the First Circuit.
Thank you.
Where you will encounter Rhode Island's own Laura Montecalvo, who has an equally distinguished appellate criminal career on the other side of the proceedings, and also Rosary Thompson, who has taken senior status but remains a leader of the First Circuit, and I think a colleague beloved by her fellow judges. So I think you'll find that you have a good Rhode Island welcome on the First Circuit when you get there.
And let me say Judge Selya as well, one of my
Exactly.
heroes.
I was going to go on to Judge Selya because he is, I think, one of the senior judges among all the circuits with a very, very distinguished and long career, and also a very considerable vocabulary,
Indeed.
as everybody who knows him will know. In Rhode Island, we have at the state level a drug court. We have at the state level a veterans court. We are working on developing a mental health court, and our United States District Court has the HOPE program for offenders. And they all seem rather aligned with your work representing the New Hampshire U.S. Attorney's Office in, I think you call it the LASER program?
Yes.
Tell me a little bit about the LASER program and tell me about what its lessons have been for you as a hard-nosed prosecutorial type like Senator Blumenthal.
So the LASER program, and LASER stands for law-abiding, sober, employed, and responsible. It was the brainchild of Judge Joseph LaPlante. It's been around for about a decade. I've been the U.S. Attorney's representative for, I think, 8 years. It takes low to medium level drug offenders who we believe have a substantial chance of rehabilitation. There's an intensive upfront vetting process in which the U.S. Attorney makes the ultimate decision. The person pleads guilty to a felony right at the front. It's a year-long program that has all sorts of both drug abuse as well as life skills. So not only is there a whole drug counseling component, but there is get your driver's license back, get a GED, get employment, all of those things so that someone might be well positioned at the end to have a productive life. And if someone completes the program, and I would say we have north of 50, less than 100 probably graduates, they do not get a prison sentence, they get a term of supervised release, and hopefully they are able to turn their lives around. And I have seen people turn their lives around through the program. So it takes careful upfront vetting, takes extensive and intensive work with the people through the year plus that they're in the program, and then it takes monitoring on the back end. But doing all of that, we have seen some good results, and I think helping people avoid incarceration, which is a good thing, I think, for these people, but more importantly, to have good lives and be productive members of the community, which we all want. So it's a very good program.
The last thing I'd ask you, knowing well that you're going to an appeals court, not a trial court, is to, through your decisions and through the messages that you send as a member of the First Circuit Court of Appeals, to encourage the use of the jury. It's locked down pretty hard on the criminal side, so we still have a lot of criminal jury trials, but civil jury trials are a vanishing species, and I think our country loses a lot when civil jury trials are discouraged. One of the remarkable things about the civil jury is that it is protected from influence, and it can make very big decisions about very big interests, and it comes for that one case, and then it's gone, so you can't cater to it over the years the way you can an agency or an official. And if you try to manipulate the jury, there's a name for that, and that's something that you would prosecute. So I think it's a really important mechanism in our system of governance that the hard, square corners of the jury box stand as a redoubt against influence and politics and the power of money. So do your best to make sure that the civil jury trial remains alive and well in the First Circuit.
Thank you, Senator.
Thank you, Senator Whitehouse. Senator Grassley?
Congratulations to you.
Thank you, Senator.
I want to get at how you might look at interpreting a statute generally, not a specific statute, but more importantly, in that the extent to which legislative history might play a role and when it would play that role in your decision-making.
So I think the Supreme Court, I think, has said To the extent it has any role, I think it's certainly a secondary role. So let me answer the question. I think as you asked it originally more broadly, I think it's clear under the Supreme Court precedent that you begin with the text. If the text is clear, you end there. There's then a whole series, if the text is ambiguous, there's no precedent on point, you look to a whole series of things. But I think you start with the statute as a whole. You look to statutes that are in pari materia with that statute. You look at canons of construction, clear statement rules. And I think some kinds of legislative history can have some purpose, such as committee reports. What I would say about that is, I think bad statutory interpretation is what I would call cherry picking, when someone just says, well, here's a quote from legislative history that I like, or a dictionary definition that I like, and then that's the answer to the problem. I think good statutory construction is a broad, if the statute's ambiguous and you're beyond the text, is looking at all of those things together to do the best you can to predict, to determine what Congress meant and what the president meant when they signed the law. That's the goal, and I think that it's all of these sources together in really being cognizant in your own mind, you're not engaging in that cherry picking that I don't think is good statutory interpretation.
Now, I don't want you to get too deep into judicial activism on one hand or judicial restraint on the other hand, but within that globe, do you believe that a judge should ever consider his or her own values or policy preferences when determining what the law means or what the case outcome should be? If so, under what circumstances?
No, I think certainly as a Court of Appeals judge, we are a court of error correction, and we are supposed to do our level best to apply the law as the Supreme Court has pronounced it. And what the First Circuit says about that is not just the narrow holdings, but the considered dicta of the Supreme Court. And that means the goal is not just to apply narrow holdings, but to figure out what the Supreme Court has said and do our level best to apply that in the broadest way to the cases before us. That has nothing to do with my personal beliefs about any topic.
What about your own life experiences? I mean, you're X number of ages now, and you've been practicing law for a long time and all that sort of thing. Is there anything in your life experiences that might influence that process?
I hope it gives me the skills to do the job well. I hope I have the temperament and the patience and the academic ability and the empathy and thoughtfulness to do a good job. But it's not that my opinions matter. What matters is that I'm doing my level best with the skills and temperament that I've developed to try to predict the law and apply it as best as I can.
What are your views on something that's very dear to me that I never get legislation passed on, but sometime I hope to? What are your views on cameras in the courtroom?
You know, so first of all, I think that is a policy decision ultimately. I've never had that experience, so I've heard myself in oral argument after, but that's to the extent. So I think one of the things that's discussed is how would that affect lawyers' behaviors in the courtroom, the trial court? I've just never had it, so I don't know if it would affect my behavior in any negative or positive way, but I know it's an issue that's out there and is discussed.
What do you believe are the most important attributes for an appellate court judge, and whether or not you possess them? Do you have attributes along that line you feel like?
I hope so. So I think they are fairness, fidelity, and clarity. So I think fairness is what you, I think, expect from any judge, which is to be open-minded, curious, thoughtful, respectful of the litigants, give it your all. I think that's the fairness component. Fidelity is sticking to that record and sticking to the precedent and what I described in my earlier answer to you about how you go about doing the job of figuring out what the law is and how to apply it. And clarity, the goal at the end of the day, right, is to write an opinion. And I want that opinion to be clear to litigants, and I want it to be clear to lawyers and judges and the bar in the community, because I think we have an obligation to explain to people what we're doing, why we're doing it in a transparent way. I hope in my appellate work that I've been doing since 2010, over 100 times before the First Circuit, I've been able to develop those skills. Certainly before Judge Howard, as a law clerk, I also had practice in those things, and I feel like I'm ready to bring them to the First Circuit, and if I'm lucky to be confirmed, I'll give it my best.
I'd like to end with a comment, if I could, about his suggesting that I was 10 years in the Senate when he was a page. You don't have to comment on this, but I hope that I told you what I tell pages today. You know, we've got this, I don't think it's a rule, I just think somebody decided that no page should ever talk to a senator unless the senator talks to them first. And I think that's a stupid rule. And so I tell every group of interns, you can talk to me anytime you want to, because you're here to learn, and if you can learn anything from Chuck Grassley, I'd like to depart it to you, and I hope I told your group that.
Well, I'll say I learned a lot, and it changed my life. So thank you, Senator.
And I've been blessed with the Grassley wisdom for so many years. Made me what I am today. Senator Blumenthal.
Thank you, Mr. Chairman. I was told never to talk to Senator Grassley unless he talked to me first.
That's wonderful, thank you.
You are a eminently qualified nominee for the First Circuit Court of Appeals, and I'll be pleased to support you. I noticed that you began in the United States Attorney's Office on the civil side, and then you moved to the criminal side. Do you think you have the kind of experience that will be necessary for you to sit on civil cases? Most of your experience is criminal.
So an interesting part of the process to get to be sitting at this table is to really look at your career in sort of a bigger way that you don't do every day. So I had 3 years at a large law firm in Boston. That was all civil. I had 3 years in the United States Attorney's Office doing employment, medical malpractice, administrative law. For Judge Howard, I would say it was 60% civil at least, and for Justice Cowan on the Massachusetts Supreme Judicial Court, it was all civil. She actually handled the criminal work, and her law clerks spent our time on the civil work. So when I added it all up, it was mostly half and half. And I'd also say to you, I have a broad interest in the law. So while my 9 to 5 is criminal law mostly, I read a lot, I listen to a lot, I think about the law generally a lot, and so it's my interest, it's my passion, and so I do think I will be able to deal with both sides of the so-called legal house, I think, well.
I think the record should note that your wife was nodding in the background when you were referring to reading a lot.
Yes. I listen to some podcasts, legal podcasts, and legal Supreme Court arguments when making dinner sometimes. My children and my wife don't love that, but, you know, it is what it is.
We won't go too deeply into that area. Let me ask you about law clerks. You'll have 2 or 3 of them. You served as a law clerk to 2 very able judges. In terms of picking your own law clerks, will you look to diversity as a qualification or a criterion?
Yes. So I think diversity is important in 2 ways. One is you want to give opportunities to people of all different kinds of backgrounds and all different sort of vectors of ways of people. It also helps the chambers. You want to have interesting, dynamic discussions, and people with different experiences bring that. So you want to find all different sorts of people, which I think puts an onus on the judge to go out and talk to different law schools, different communities within the law schools. And I'll say one other thing that I think that I learned this at the First Circuit conference that was about a year ago. There was a diversity panel, and I attended the panel. And one of the judges said that you will eventually hire a law clerk that you didn't think was great. And you might be inclined to associate that lack of greatness, so to speak, with some attribute of the person. Don't do that, because that's what stops diversity, and it's to realize that it's not the characteristic. It's just that decision wasn't the best one, and just keep going. And I hadn't thought of it that way, but I thought that was an insightful remark. So I think it's both going out and finding all sorts of different people to work in your chambers, and then reminding yourself that, you know, to keep going. And that's what I would try to do.
Thank you. Thank you very much.
Thanks, Senator Blumenthal. Senator Blackburn?
Thank you, Mr. Chairman, and congratulations to each of you. We always love getting to know more about our nominees, and I think it's wonderful when their families can come and be a part of the day. Mr. Ephraim, I want to come to you. I know you're aware of the circumstances around Michael Delaney's withdrawal for his nomination, and of course, the fact that he had used those hardball tactics against a minor girl who was a victim of sexual assault and chose to report it and chose to go forward with that prosecution, and the fact that he chose to name, to shame, and to really humiliate her is something that this panel objected to, and he did withdraw. And I was hopeful that we were going to see that the White House would bring us nominees that did not have questions. And I know you've talked a little bit about the Smith case, and I will get to that. I do want to go first to the Carpentino case. This really disturbed me. And I'll say it really disappointed me. So do you recall that case?
Yes, Senator.
Okay. Now, that case, for my colleagues, so that they're aware, this man kidnapped a child and took her to an abandoned motel in Vermont, and then he raped her. But it was not the first time that he had abused children. In the sentencing memo that you wrote as the prosecutor, you noted that the defendant had just been released. He had just been released. So we learned that he was a convicted felon on multiple counts. So he had just been released from a 13-year prison sentence for sexually assaulting minors. Now, he repeatedly stripped his victims naked and attempted to sexually assault them while they tried to push him off. In one case, he smothered a little girl with a pillow while he raped her. In another case, he got so violent that he punched the victim in the face. By your own account, he was a sexual predator who was a clear and present danger to children in the community. Despite all of this, you still recommended a sentence far below the probation officer's suggested guidelines. Isn't that correct?
I mean, I don't know what the probation officer's recommendation was. 405-month sentence is well beyond 30 years in prison, Senator.
I'll be happy to tell you what that was, because I've got a memo on that. You recommended a sentence that was below what was recommended. In your sentencing memo, you wrote, and I'm going to quote you, "The sentence requested here will incapacitate the defendant until he is in his 60s. You knew what that sentence was. Hopefully, by that time, the danger that the defendant presents will have subsided." Mr. Ephraim, hopefully. Really? Hopefully? Hopefully? You're going to deliver justice to this guy who has a record? He's a sexual predator. He has raped these children. Were you really basing your sentence on hope?
Senator, I was basing my sentence on the sentencing guidelines, and that sentence...
No, sir, you did not follow the sentencing guidelines. I am sorry. I will be happy to submit that to you. Let's talk about the Smith case. This one made me want to throw up. I have a 3-year-old granddaughter, 3 years old. And the fact that this man he was guilty of manufacturing pornography. He created 6 videos of himself sexually abusing a 3-year-old girl. he did this. You noted that the most poignant evidence of the harm this victim caused was the look of fear in the young girl's eyes. This is astounding. And despite this, you recommended 60 years, even as the guidelines recommended life in prison. You just said you couldn't give him life, but no, the guidelines said you could give him life. How in heaven's name, sir? How could you let somebody off that raped a 3-year-old child? It is beyond me. I don't see how you could possibly have advocated for anything other than life for what he had done, and that is what the guideline called for.
Senator, the guidelines are overridden by the statutory maximums. 30 years is the statutory maximum for production of child
The
pornography.
guidelines were for life. Thank you, Mr. Chair.
Do you want to finish the sentence?
Sure, Senator. The guidelines provide a sentence, but ultimately what controls are the statutes, and the statutes are 30 years for each kind of child pornography production. He was convicted of 2 counts. The statutory maximum was 60 years, as I remember the case.
Senator Padilla, are you? Senator Kennedy, why don't you go ahead? Senator Padilla is preparing. Senator Padilla.
Mr. A-Frame, how are you?
Good, Senator. How are you?
I'm well. What is rent control?
As I understand rent control, it's some cities may have laws that limit the ability of landlords to raise rent, but it's not something I'm that familiar with.
Okay. Well, why isn't that a taking that merits compensation from government?
I don't know whether that's been litigated or how that's been resolved. I have never dealt with rent control.
Well, I want to understand what you think about it, how you think. Why isn't it a taking? I mean, your government is taking money from the private owner of an apartment. Why isn't that a taking, just like if they took his property to build a highway?
So I'm not well-versed enough in takings to give you a definitive answer, but I'll give you what I know about takings.
No, tell me what you think. Tell me how you would analyze that.
I would be looking at the precedents that say to what extent can government regulation be permitted.
Suppose there are no precedents. I know you will stipulate you would look at precedents.
But
I want to know how you would analyze that case.
Well, the question is, what can the government do as far as regulation where there's still value in the property, but maybe not the maximum, and does that constitute a taking? That's what I'd have to study. I don't know the answer about that.
What do you think about it? How would you analyze it?
Well, from what I know about...
What are the competing interests?
Well, the competing interests are the government's interest in housing, I would think, on one side, the property owner's interest in making the maximum amount of money on the other.
Well, why couldn't the government, it has a legitimate interest to help poor people. Why couldn't the government accomplish that by just allocating some tax money to housing subsidies? And then you don't have to take somebody's private property.
That would be a policy decision, another way to try to get at that end. You're asking me whether it's a taking.
Yeah,
and I think that I am not sure that a limit on how much you can make constitute a taking, but I don't know that for sure. I would need to think about that and study that.
Well, aside from if you were back in private practice, how would you analyze that? How would you reach a decision?
Again,
please don't tell me you go look at precedent, because you're not going to find much.
I know that there are cases about regulation that limits the value of property. And I believe that those cases say, unless the property is basically brought down to no value or very little value, it's not a taking. That's my memory.
No,
and that would be relevant.
That's
but
not
I could be wrong about that.
You can have a highway come through and take part of your property, which diminishes the value. But you've still got to compensate the landowner, and you've got to compensate the landowner for consequential damages as well. That's clearly a taking. Why is rent control any different, Counselor?
Senator,
Achieve a government purpose in a less discriminatory way? Why isn't this open and shut?
well, Senator, without doing more work on it, I mean, I tried to tell you what I would think about it, but I'm also telling you I don't know necessarily how it would come out, and I would need to read and think about it more. But I would think about the government interest, understanding that there is a loss to the owner of the property, and figure out how those interact.
Okay, what's the new rule about how flexible an employer has to be if an employee asks for an accommodation because of a religious belief?
There has to be, the employer has to suffer a substantial hardship, which is a change in the law. The law was more, gave employers more flexibility in that area, and there was, I think the cases DeJoy from last term made that more difficult for employers, raised the burden on them.
Okay, fair enough. You will faithfully follow precedent, is that right?
Yes, Senator, I will do my very best to do that, yes.
Would you have followed the Dred Scott case?
As a lower level judge?
Yeah.
I mean,
It's a yes or no.
I think that, Senator, I mean, there's a fidelity of lower court judges, and hopefully our Supreme Court would make the right decision
You
there.
have followed the Dred Scott case.
As a lower court judge, I think you have no choice, but you can write that the Supreme Court should do something about that, and I would have.
Would you have followed Plessy v. Ferguson?
It's the same answer. You have to. Agostini versus Felton said lower court judges must follow Supreme Court
Why
precedent.
wouldn't you quit first?
Well, I guess I hadn't thought of that option, Senator, but I would certainly make my voice heard, but I would have to follow the
Dred
precedent.
Scott was an immoral decision, do you?
Yes, Senator.
Okay, why wouldn't you quit?
Perhaps I would. I hadn't thought about it like that, Senator. I don't know. I hadn't thought about that.
Okay.
But I would make my voice heard. But I do want to say that in a vertical court of judicial system, it is critical that middle-level judges do their best to follow precedent.
Thank you, Mr. Chairman.
Thank you, Senator Kennedy. Senator Padilla.
Thank you, Mr. Chair. Just on the topic here that Senator Kennedy is leaving us on, I can't help but reflect on this. Now, I'm not a judge, and I do not play one on TV. But as a member of this body, sometimes we can speak to leadership and the need for institutions to reform. And sometimes it is strategic and effective to leave an institution and try to change it from the outside. Sometimes it is imperative to remain within an institution and change it from the inside. There's no right, wrong, good, bad, just different ways to approach it. That's not a question, that's just a statement, unless you care to comment, but actually have a comment that would be constructive for the deliberation of the committee. I understand that several of my colleagues have raised questions earlier in the hearing about a case, United States versus Carpentino. And so for the record and for clarification, I want to ask this. As the prosecutor in the case, what sentence did you ask for and what did the judge ultimately impose?
My belief is that we asked for 405 months, which is well beyond 30 years. And I think the judge imposed 384, I believe. But it was slightly lower, I remember, than what we asked for.
So your involvement in the case is a question/concern for some of my colleagues. And so to make sure I understood you clearly, you asked for a higher sentence than what was ultimately imposed. Is that correct?
That is correct.
Thank you. Very helpful. Now, my other question is important. I ask it of all the nominees that come before this committee, and in some ways is building on a question that Senator Blumenthal asked earlier about law clerks. I have come to appreciate how a federal clerkship is a fantastic starting point for a legal career, one that helps young lawyers to excel and often forms the basis of serving the top ranks of the nation's legal profession, whether it's in the judiciary, whether it's in private practice, whether it's elsewhere. But far too often, women and minority law students are not chosen for federal clerkships, despite having comparable, sometimes more than just competitive credentials and skills. You answered Senator Blumenthal's question about what you would do to help diversify the clerk should you be fortunate enough to be confirmed. But can you just take a moment and explain to me why you think it's important, why you value diversity in the courtroom and in the field?
So you provided, I think, one of the answers, I think, which I completely agree with, which is opportunity. Certainly an opportunity for me. It's been an opportunity for many other people that I know, and it's a pathway that I want to make available to as many people as possible. That's one. But there's a selfish side to it. Part of this job I'm really looking forward to is the dynamic of my chambers and talking with young people about interesting legal topics. And those conversations are more interesting if you have people who have done different things and been different places and have different backgrounds. And so that's the dynamic I want to have. And diversity is part of that. And so it's both to help the clerk, who I hope to mentor through their career, that's certainly part of it, but it's also for me to have that dynamic environment that I hope to have.
So I appreciate that answer. And just in closing, we'll also share that big picture, it improves public confidence in the judiciary. When the judiciary more comprehensively, not just who's sitting on the bench, but more comprehensively reflects the diverse nation that it serves. So thank you for being here.
Thank you, Senator.
Thank you, Mr. Chair.
Thank you very much, Mr. Ephraim, for appearing before us. We will possibly send you some written questions, which we hope you can answer on a timely basis. Thank you very much.
Thank you.
Now I ask the second panel to approach the table. Please raise your right hand. Do you affirm the testimony you're about to give before the committee with the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Let the record reflect the nominees have answered in the affirmative, so we're going to let them proceed. Mr. Keel, I'm going to recognize you first for 5 minutes.
Good morning, Chairman Durbin, Ranking Member Graham. Thank you for scheduling this hearing. I thank President Biden for the honor of this nomination, and to my home state senators, Robert Menendez and Cory Booker, for their support of my nomination and for their kind remarks this morning. I would like to first introduce some very important people in my life who are here today. First, my wife, Nancy. She is my greatest cheerleader and supporter. She's my best friend and a wonderful mother to our 3 children and a successful and a well-respected ophthalmologist. And I'm so happy to share this moment with her. My mother, Grace, is here, and Senator Booker and Senator Menendez were kind enough to tell a little bit of the backstory. My father and mother were refugees from North Korea who fled south during the Korean War. They lived in Daegu, Korea, where my 2 older brothers and I were born. My father came to the United States to study at Princeton Seminary, sent by Christian missionaries. My mother, older brothers, and I joined my father in the United States a couple years later, and we settled in New Jersey, where my father founded one of the oldest Korean churches in New Jersey, and where my mother worked at a dry cleaners to support my father's ministry and our family. My father passed away in August at the age of 97 after a fulfilling and very accomplished life. My brothers and I have reaped the rewards of our parents' unwavering faith and belief in the American dream. My 2 brothers are here. My oldest brother, Sam, is a pediatric anesthesiologist at a leading children's hospital in New Jersey. My middle brother, Paul, was a nuclear engineer for the Navy, a veteran of the first Gulf War. He is now an in-house patent attorney. My 3 children are here. Elizabeth, she just graduated from Wellesley College in Massachusetts and is now working in New York City. My twins, Andrew and Amanda, are juniors in college, Amanda at Villanova University and Andrew at Vassar College. My children are wonderful young people that my wife and I are so proud of. Finally, for family, my niece is here, Elena Chu. She just graduated from University of Virginia Law School and is working in big law here in D.C. Also in attendance are my law clerks, Usma Khan, and my courtroom deputy, Shay Smith. And I would like to acknowledge my two other law clerks, Brian Sopranowitz and Samantha Greenfield, who are back in chambers and holding down the fort there. And finally, I want to thank my federal family back in the District of New Jersey. The judges and staff of our great district serve the public with honor, distinction, and dedication. Thank you all for your support and encouragement throughout the process. Senators, thank you for your time, and I look forward to answering your questions.
Thank you, Judge Keel. Professor Russell.
Thank you, Chairman Durbin, Ranking Member Graham, and members of this committee for considering my nomination. I want to thank Senator Blumenthal and Senator Murphy for their tireless work on behalf of the people of Connecticut and for this country. And I also want to thank you, Senator Blumenthal, for your incredibly kind introduction. I will try to be worthy of it. I want to thank President Biden for this nomination. It's the highest honor of my professional life. I want to say a special thank you to the Honorable Michael B. Mukasey, who is traveling to be here today. He experienced some flight delays, so he's en route, and he told me to talk slowly, so hopefully he'll make it. Following law school, I clerked for Judge Mukasey in the Southern District of New York. I saw Judge Mukasey approach each case with an open mind, bringing to bear careful study of legal precedents and a keen appreciation for the facts of each individual case. Judge Mukasey's love for this country and his total commitment to uphold the rule of law continue to inspire me. I also had the honor of clerking for the Honorable Chester J. Straub of the Second Circuit, who is a model of impartiality and collegiality. I was so fortunate to clerk for these brilliant judges who approached their work with humility and treated all they encountered with the utmost respect. With me today is my husband of 17 years, Sean. Thank you, Sean, for your love, support, and encouragement over all these years. Sean is sitting with our three incredible boys, ages 10, 13, and 15. Between the three boys, they are missing 8 different football and ice hockey practices to be here to support their mom. I appreciate you boys for coming, for sitting still, and for being the great kids that you are. My parents are also here. They came here directly from Texas, where they were helping to take care of my brother's baby twin boys. Growing up, my parents always put us kids first, and now they dedicate countless hours to caring for their grandchildren. My parents taught me the importance of working hard and giving it your all, no matter what you choose to do. Thank you, Mom and Dad, for being here and for your unconditional love throughout my life. I'm so glad to have my sister Kristen here and my dear friend Laura as well. My in-laws, the Doyles and the McElligotts, are watching from Connecticut. Also watching from Connecticut are my colleagues and students at Quinnipiac University School of Law. I have friends, family, and mentors watching from around the country. I would not be here but for your support and your belief in me. Thank you to the committee for considering my nomination, and I look forward to answering your questions.
Thank you, Professor. Mr. Fanzone.
Chairman Durbin, Ranking Member Graham, and members of this committee, I'm honored to appear before you today. Thank you for scheduling this hearing and for taking the time to consider my nomination. And thank you, Senator Durbin, for the kind introduction. With your permission, I would like to express my gratitude to a few members of my family. My mother, Marianne Fanzone, is watching today's proceedings from her home in Allentown, Pennsylvania. She's probably only slightly less nervous than she was the last time she watched one of these hearings. She and my father instilled in me and my brother Steve from a young age the importance of trying to do the right thing, and without their guidance, I would not be here today. My wife, Jill, is with me today, and there's really nothing more to say than I can't thank her enough for her love, counsel, patience, and good humor. Without her support and encouragement, I would not be prepared to undertake this challenging role. I would also like to thank President Biden and Attorney General Garland for the confidence they have shown in me with this nomination, as I have seen firsthand the importance of the Office of Legal Counsel's unique mission. In particular, earlier in my career, I had the privilege of serving as an attorney advisor in the office. While doing so, I was able to observe how the office sought to advance the rule of law and contribute to the important work of the country by carefully deliberating over difficult legal questions and providing officials across the executive branch with candid, independent, and principled legal advice. The importance of OLC's mission became even more apparent to me later in my career. As the legal advisor to the National Security Council, and now as the General Counsel of the Office of the Director of National Intelligence, I have often confronted difficult legal questions that have significant implications for the intelligence officers, service members, and diplomats who are doing difficult and often dangerous jobs far away from home and who are committed to protecting the nation in a manner consistent with the Constitution and the laws of our country. I've always endeavored to provide my clients with the most timely, practical, and sound counsel that I can on those questions. But I've also learned that precisely in these circumstances, when you're facing difficult legal issues and the stakes are high, that it's most necessary and helpful to be able to pick up the phone and seek advice from an office that is simply dedicated to providing its best view of the law. That's why, if I am fortunate enough to be confirmed, it would be an honor to be able to draw on my experience as an executive branch lawyer to assist others in precisely the same way that the Office of Legal Counsel has helped me. Put simply, I think it's impossible to replicate the sense of mission and purpose a lawyer feels when they're trying to work through a difficult legal question in the service of their country, and it would be the privilege of a lifetime to return to an office whose work lies at the heart of that task. I'm grateful for your consideration today and welcome your questions.
Thank you, Mr. Franzone. Now we'll do a round of questions from the members of 5 minutes each. Professor Russell, I'll start with you. I've been through a number of these hearings for nominees. I consider this panel, like most of the others, in fact, virtually all of them, well-qualified people. The obvious questions which will be asked are related to your temperament, your knowledge of the law, and any prejudice you bring to this aspiration. You, of course, having written extensively on sentencing and been engaged in public defense, may raise some questions among some panelists. Would you like to address that initially?
Thank you, Senator. So I began my career, as I mentioned, as a law clerk. So I saw firsthand, first clerking for the Honorable Michael B. Mukasey in the Southern District, and then for Judge Straub on the Second Circuit. I saw firsthand the role of the judge. And in both these judges, I saw them approach cases with an open mind and bring to bear impartiality, setting aside any of their past experiences or views. So I know what it means to be in that role as judge, and I know how different that role is from an academic or a policy advisor or from someone who is an advocate in the court system. So in my career, I have held those different positions. So from being a law clerk, I moved to be an assistant federal public defender, and then I moved into clinical law teaching, and so have worked with students to represent indigent clients in a range of different types of cases, mostly civil, and most recently at Quinnipiac Law School. And we have done all different cases in state court, in federal court, before administrative agencies, helping people not just with issues related to the criminal justice system, but also with child support issues, with employment issues, and a range of different issues. So I do think my career has had a broad scope, and I have also had the opportunity to be a policy advisor of types in issues as well. Finally, I'll say, Senator, that I've been called upon the court to serve in some other capacities. So I serve as counsel to our Federal Grievance Committee for the District of Connecticut, and that's position that the Chief Judge asked me to serve in. And the Chief Justice of the Connecticut Supreme Court had previously asked me to serve on the Committee for Judicial Ethics. So I've worked with the court system in those capacities as well. So I do think I have had a broad career and now have a sense of the role of judge as being quite different than those other roles I've occupied.
And certainly your service as clerk to Judge McCasey brings to this panel, well acquainted with the judge, an indication that you have at least dabbled in the political spectrum when it comes to legal questions. So thank you for that. Judge Keel, what an amazing story you have in your family, a family of immigrants who came with nothing and made such a great life here in this country. Please share with us any thoughts you have that, as your aspiration to this judgeship is underway, as to what that means in light of your family background.
Sure. Thank you, Senator. Senator Booker spoke about the entire circle that I've come to, where my parents were naturalized in the same courthouse where I now sit. And it means so much to me. At my investiture, I surprised my parents with a framed portrait of their naturalization certificates, and those are hanging at the entrance to my chambers as a constant reminder of what an incredible country that we live in and the opportunities that we have. I do want to make one correction, and Senator Menendez talked about my mother putting in the $40 at the offering plate on that first Sunday, and my mother is sitting here at my investiture. When I said that, she took me aside afterwards and said, the next time you talk about that, it was $50. So get it right. So, Mom, I got it right today. But, Senator, it is an incredible legacy, an incredible gift that our parents have given to us to get to the successes that my brothers and I have. Thank you.
We have a common experience. My mother was an immigrant, and her naturalization certificate is behind my desk in my Senate office, and on the corner is a little receipt for the filing fee of $2.50. Okay. And I asked her why she kept that receipt, and she said, if the government ever challenged me, I can prove it. But I paid the $2.50. Thank you very much. Senator Kennedy. Senator Hawley.
Thank you, Mr. Chairman. Congratulations to the nominees. Thanks for being here. Judge Keel, let me just start with you. You're involved, I think, with a group called the Asian American Legal Defense and Education Fund. Have I got that right?
I did a couple cases with them, Senator. It's probably been 15 years at least since I did any work with them.
Okay, fair enough. Have you done some fundraising for them? Do I understand that correctly, or am I misinformed?
I don't believe I've ever done any fundraising for them.
Well, let me just ask you about, I'm curious because of some things they've said recently, so just let me ask you about this and you can give me your viewpoint on it. Earlier this month, right after the attacks on Israel, the AALDEF said that it stands in solidarity with Palestinian, Arab, and Muslim communities, and went on to help push out on social media a toolkit. That's their word for student protesters that we've seen on our campuses, including resources, talking points, and chants for students who are pressing to end the genocide in Gaza, which of course we've seen invoked by those who are calling for the destruction of the state of Israel. So let me just give you a chance to respond to that. What's your view on that? How do you read this? I mean, how do you read this statement from this group? Just let me give you the opportunity to respond to that. How about that?
Senator, I have not had any involvement with the group for a very, very long time, and my only involvement was representing restaurant workers and wage and hour claims. I'm not familiar with that statement from ALDEF, so I'm not sure that I could comment on that.
Fair enough. Let me just ask you, I assume that doesn't represent your views, your personal views, the position that the group has taken here with regard to the attacks on Israel?
As I said, Senator, I'm not sure in what context or what that statement was. I haven't read the full statement, so I can't really tell you whether I...
Well, how about this? Why don't I give you an open-ended chance to say, with regard to the attacks on Israel, the threats on Jewish Americans, what we're seeing on our college campuses where we have some student groups out there saying from the river to the sea, Palestine must be free, which of course is a call for the elimination of the state of Israel. Why don't you just tell us what your views are on that?
Senator, it's a very complicated issue. I haven't really studied it. It is a terrible situation, what is going on there. And Senator, that's all I can really say what my personal views are.
Well, let me put it to you this way, would you condemn those who are calling for, who say things like from the river to the sea, which is a call for the elimination of the state of Israel and frankly, the killing of Jews in the Middle East? I mean, would you condemn that?
Senator, as I said, I know it's a very complicated situation. It's a tragic situation. I haven't studied the situation. I don't know how I can answer that today, Senator.
Because go ahead.
As a judge and the role that I would be playing, my personal views of things would not come into consideration, certainly, Senator, and I would keep an open mind for all matters that come before me, and that's the way that I would approach the job of a judge.
I totally understand that, and I'm not asking you to comment on any case. I just am I wanted to give you a chance to respond to this group statement, but let me just see if I can get you to understand your views here. Just with regard to the attacks on Israel and the violence in this country against Jewish Americans, you condemn all of that. You have no truck with that. You would say that we should condemn all of that explicitly, I assume, right? I mean, I don't want to put words in your mouth. I mean, you tell
me. Yes, Senator. Any violence here in this country against Jewish people should be condemned.
Okay, and these protests that we've seen where people are explicitly calling for the elimination of the state of Israel, we had Jewish students at Cooper Union in New York who were barricaded inside a library for hours while pro-Hamas protesters banged on the doors, shouted at them, screamed at them. You condemn all of that, I assume.
I'm not familiar with that situation, Senator. I know nothing about it.
Are you familiar with the campus protests that have happened all across the country? The Senate's addressed this in a resolution that passed unanimously condemning that rhetoric of genocide, frankly, against the Jews. I'm just trying to get you to say, I hope, that you condemn that, you think that's wrong, you're against it.
100%, Senator. I would condemn the genocide of Jewish people.
Okay. Yeah. Mr. Fonzone, let me very quickly, because I'm almost out of time now, and there are lots of other senators who want to ask you questions, but I just want to ask you quickly about some work, and we follow up in written questions, but some work you've done for the People's Republic of China, different entities. You did some work for Huawei, I think, in 2018, for the Ministry of Commerce of the Chinese government, and then for the Hong Kong Trade Development Council, if I'm not mistaken, in 2019 and 2020, another governmental entity. That was right during the Hong Kong protests. My question to you is, and I'll give you some more for the record, but my question for you is, did you advise that council during that time of the Hong Kong protests on messaging, on what was happening there? I mean, tell us about your work.
No, Senator, thank you for the question. I know this is an issue of interest to the Senate. It came up in my last confirmation process as well. I think in general, my practice in private practice was focused on advising companies on American law and how American law worked. For the three entities you just mentioned, I did a small amount of work at the request of other partners, much of it many years ago. None of that work has affected my ability to give objective advice in my current role at the Office of Director of National Intelligence, and none of it would if I was fortunate enough to be confirmed at OLC.
This is my last thing, Mr. Chairman. Just last question. But did you in 2019, 2020, at the height of those protests in Hong Kong, which the government brutally repressed, I saw it with my own eyes, did you give the Trade Council any kind of advice involving issues related to those protests?
No, the advice, and I obviously can't get into privileged information, but the advice we gave was, the work I did was basically on advising them on issues related to my practice, which is around privacy and cybersecurity.
Senator Whitehouse.
Thank you very much. Mr. Fonzone, welcome. I hope we will get through the issues I addressed earlier and we can proceed swiftly to your confirmation. I served as United States Attorney back in the Clinton administration, and at the time, the Office of Legal Counsel was viewed essentially as the high temple of legal excellence and integrity. And since I've been in the Senate, things have gone rather awry. We first had the warrantless wiretapping opinions, which were so appalling that when they became public, the colleagues of OLC in the Department of Justice threatened to resign en masse if the program was not restructured, notwithstanding OLC's prior secret opinions approving of it. Then, not long after that, the torture program came along, again supported by OLC opinions, in this case so bad that the department actually turned around and withdrew the opinions. And indeed, they were so bad that the department later offered the opinion that OLC lawyers were not subject to the duty of candor, that an ordinary workaday lawyer going into the J. Joseph Garrahy Judicial Center in Providence, Rhode Island, with 6 files under his arm is subject to on a busy, busy day, that these elite, Ivy-educated, super high-performing lawyers would not be held even to that standard. Now, that did quell the problem of how bad the opinions were, but it set, I think, a very bad example by exempting OLC from the most basic standard for workaday lawyers. And then we moved on to the issue of executive versus legislative access to documents, oversight, and so forth. And as you know, OLC used to, under the Reagan memo, which is still nominally in play, used to have a duty to be kind of an ombudsman or arbiter, to take a fair and neutral position and try to find common ground between the legislative ask and the agency priorities. That changed dramatically to the point where the OLC became the outermost reach of the most arcane and exotic doctrines of executive supremacy, virtually autocratic doctrines. And then when those doctrines appeared in Article III courts and were mocked and rejected, the position of OLC was, well, that wasn't the Supreme Court, so it doesn't count. As you were advising companies, would you overlook a district court decision in the jurisdiction in providing advice about what that company should or shouldn't do?
So, Senator, there's a lot there. I guess I'd
just that last question. I'm not asking you to respond to the whole mess.
Yeah. Obviously, when I was advising companies, I would not advise them to ignore relevant precedent.
Yeah,
and I think
I mean, it just seems a little weird that OLC treats itself like it's another circuit court of appeals, and its judgments can only be repaired or corrected by the United States Supreme Court. It leaves an enormous gap between what the law is and what OLC is telling people that can persist for years and years and years and years until the Supreme Court addresses it. And it's a matter of real concern for us because we think, I think in Congress, that a lot of the ideas that the OLC has propounded are really, really badly wrong. And Senator Kennedy and I have worked together on finding an alternative method because we've given up on the good faith and neutrality of OLC in this regard. So we're creating, in a bipartisan fashion, with a bipartisan report and a bipartisan bill, an alternative. So given this challenging history for what used to be the high temple of legal excellence, we can have this discussion more, but I'm interested in what guardrails you think OLC should build for itself to prevent another warrantless wiretapping fiasco, another torture opinions fiasco, and another walk away from department policy as expressed in the Reagan memo and from the rule of law where Article III courts have opined.
Thank you, Senator. And I'm not going to sit here and say OLC's always gotten it right. As you've said, there's times when they haven't gotten it right. And I think the only thing the office can do to establish trust is to deliver the best advice it can, frank and independent advice, and to do that consistent with its best practices that have been stated publicly, which I think there's 3 main sort of buckets of them. One is that it gives frank, independent advice that's its best view of the law, independent of the policy preferences of any administration. Secondly, that it only gives that advice after rigorously vetting it and after thorough deliberation between the career attorneys in the office and the appointed leadership. And then third, to the extent it can, it makes its advice public, so it could be subject to scrutiny. OLC answers the type of questions not everyone's always going to agree upon, but I think it owes it to the American people to give advice consistent with those best practices.
Thank you, Chairman. To be continued.
Senator Graham.
Thank you. Mr. Fonza, is that right? Fonza, did I get it right?
Fonzone, yes.
Yeah, thank you, sir. You did legal work for Huawei, is that correct?
I did. When I was in private practice a number of years ago, I did a small amount of work at the behest of my
So is pretty well the policy of the United States to tell our allies that if you buy Huawei technology, we're not going to do business with you because we think Huawei is an extension of the Communist Party and it would get into all of our data and it would be a national security threat. We've actually told allies, if you join Huawei, we're going to shut down sharing with you. Are you familiar with that?
I'm aware of some of the work the United States government.
Based on what you know about Huawei, is that sound policy?
Senator, I think I did a small amount of work for Huawei a number of years ago.
No, that's not my question. Is, I mean, you did a small amount of work for Huawei. I'm not holding your client against you. I just want to understand, do you know who you're representing here?
Yeah,
I mean, Huawei is considered by our government a threat. So if you're an ally of the United States and you buy the Huawei systems, we're going to shut down sharing information. That's the policy that I support. Does that make sense to you, given what you know about Huawei?
Senator, a lot of time has passed since I represented Huawei. Things have changed. I have no reason to second guess the policy of the United States in this ground, and I think more importantly for my current role is for the role of the
during your time representing them, did the way they do business give you any concerns along those lines?
Yes,
I mean, Huawei is owned by the Communist Party, basically, right?
Senator, I can't remember my thinking at the time.
Yeah.
What I can say is that OLC is not a policymaking office.
I got you. The Hong Kong Trade Development Council. So you're familiar with those folks, right?
Much like Huawei, I did a small amount of work for them.
Yeah. So during 2019, the government of Hong Kong went hard against pro-democracy protesters, and the Hong Kong Trade Development Council seems to be behind the governor of Hong Kong, whatever you call the guy. Did you ever say anything to them about what's going on in terms of this will not good?
Senator, my work for the Hong Kong Trade Development Council, much like my work for Huawei, was done at the request of other partners, and
I understand
had no
that.
interaction
I mean,
with.
everybody deserves a lawyer. I mean, trust me, I've represented people I don't agree with. That's not the point. The point is, it seems to me that during 2019 was a crucial time for democracy in Hong Kong. And that was a time where I would expect people to stand up and be counted, not provide comfort. So did you ever, or anybody in your firm, ever suggest to the Chinese Hong Kong Trade Council that what you're doing is going to put you on the wrong side of the United States and out of line with international law?
I can't speak for everyone in my firm. I had no direct interaction with them, so.
Okay. Thank you very much.
Thank you.
Senator Blumenthal.
Thanks, Mr. Chairman. Mr. Fonzone, I'm not sure I would agree with my colleague, Senator Whitehouse, that the Office of Legal Counsel has been ever the high temple of jurisprudence. But I'd just like to ask you if there is ever any attempt to shape or interfere with your judgments as head of the Office of Legal Counsel, will you disclose those efforts to this committee?
Senator, I think it's incredibly important the Office of Legal Counsel gives frank and independent advice. I know the President and the Attorney General share that view. I don't know if I could say here today, because there might be confidences in terms of things that are disclosed to me, but if I was confirmed, I would resist any effort to put undue pressure on the office and make sure that any advice I gave was free of any policy preferences.
You'd not only resist, but you'd object and reject any efforts to impose pressure. I don't know what undue pressure would be, but any pressure, because above all else, the Office of Legal Counsel is supposed to be independent, correct?
That's correct, sir.
Ms. Russell, welcome to the committee. Thanks for your service. Your life has been really dominated by a career of public service. And I won't go into all that you've done, but I think one aspect that particularly has impressed me is your work on behalf of veterans and others who all too often are voiceless or vulnerable in our system, often overlooked. Could you describe perhaps some of what you've done on behalf of veterans at the clinic, not only at Quinnipiac, but also the Yale Law School?
Thank you, Senator. So it has been my privilege to work with veterans, and our clinic at Quinnipiac receives referrals from the Connecticut Veterans Legal Center. And so on a number of occasions, we have taken cases and had the opportunity to represent veterans. Some examples involve cases involving child support issues or other family law issues. And it's been a terrific opportunity for the students to get to work closely with clients. These are often people suffering from disabilities, sometimes people who've experienced homelessness and other challenges. For the students to get to work firsthand and represent a client, get to go to court, stand next to the client and speak on their behalf in court has been an incredible experience for me as a teacher, as I teach students to be competent and ethical lawyers. And the clients have been really appreciative of the time that we've been able to devote to their cases. I have also had students who are veterans themselves. And so one student had the opportunity to do a trial we had in federal court in a case. And so I got to see him for the first time become a lawyer in court, cross-examining witnesses and helping to put on the case. And I also had the opportunity to work with him as a student in preparing testimony related to a veterans law issue for the Connecticut General Assembly. So all those have been wonderful experiences in our clinic to serve the public in different ways.
I might just say, coincidentally, a number of us met this morning with various veteran service organizations, including Allison Jaslow of the Iraq and Afghanistan Veterans Organization. She particularly cited the work of these clinics in helping many of her veterans. And, you know, you have served on the court's grievance committee. Chief Judge of the District of Connecticut appointed you to serve on that body. The Chief Justice of the Connecticut Supreme Court appointed you to serve on the Judicial Branch's Committee on Judicial Ethics. Two of our governors have appointed you to serve on the Sentencing Commission. You've been on the advisory board of the town of Hamden's Juvenile Review Board. So in many different capacities, you've led a life of public service. I want to just anticipate maybe one of the questions that will be asked by some of my colleagues. You served on the Sentencing Commission with prosecutors, law enforcement officers, and victims advocates, and a number of recommendations were made, some of them dealing with the sex offender registry in Connecticut. I am very familiar with the sex offender registry because I defended sex offender registration laws before the United States Supreme Court. I argued the case. We won it. Laws were upheld. This modification to the sex offender registry was made by that commission to bring it into line with other state statutes, as I understand it, correct?
Thank you, Senator. So there was a proposal developed by individuals on the Connecticut Sentencing Commission, which include victim advocates, prosecutors, police chiefs, and others, to move to a risk-based system from an offense-based system. So I was involved as a member of the commission in developing that proposal.
Thank you.
Thanks, Senator.
Thanks, Mr. Chairman.
Senator Blackburn.
Thank you, Mr. Chairman. Mr. Chairman, pertaining to Mr. Ephraim from the previous hearing and panel, and we discussed the Smith case, I went back upstairs and pulled the sentencing memo. I've highlighted where the sentencing guidelines recommended a sentence of life imprisonment. I'd like to submit that for the record and clear the air on that issue.
Without objection.
Thank you. Mr. Fonzone, I do want to come to you. Your position, if you're confirmed, would hold you responsible for reviewing all executive orders, providing legal guidance to each agency in the executive branch, and working closely with A.G. Garland, correct?
That's correct.
Okay, let's talk about this in light of the work you've done for the Chinese Communist Party and for Huawei. Because as Senator Graham said, we're going through a process of ripping and replacing Huawei equipment here in the U.S. And I'd like to know if you regret your work for Huawei, if you regret your work for the Chinese Communist Party, and if you regret advocating for the Chinese Ministry of Commerce, their MOFCOM, which in essence you would have been turning your back on American workers. Do you hold those actions in regret?
Senator, thank you for the question. As I said in response to the earlier question, I did a small amount of work at the request of my partners a long time ago. It hasn't affected my ability to, in my current role, to serve in my current role and provide objective legal advice as the General Counsel of the Office Director of National Intelligence. It would not affect my ability to serve at OLC. A lot of time has passed since I served on a moot court for a partner of mine who was arguing a case for the Ministry of Commerce.
Okay, my time is limited,
Okay.
but you doubled down on this. You did more than just a little bit. And I think one of the things that concerns me is basically your work with the Chinese Ministry of Commerce. You were advising them on how to game the system, the American system, and that causes me concern. Let me ask you this, because you're going to be working with A.G. Garland, and there's been a lot of conversation from Tennesseans that I represent. They're very concerned about two tiers of justice and how this affects their lives. So I think it's important that you have the opportunity to assure the American people that you are not going to participate in two tiers of justice. And I'd like for you to weigh in for just about 30 seconds. Do you condemn the politicization of the Department of Justice and the actions that have taken place there against parents, against pro-lifers?
Senator, OLC is not a policymaking office. If I'm fortunate enough to be confirmed, OLC's role is a reactive one. It answers legal questions presented to it by other parts of the executive branch. And if confirmed...
Do you condemn the politicization of the department?
Senator, my role at OLC would simply be to provide frank and independent legal advice.
So, okay. All right. So you're not going to do that. Okay. Mr. Keel, let me come to you. I think your mom deserves Mother of the Decade. And I'm delighted that she's here. Senator Hawley came to you on a question about ALDEF and some of their lack of ability to condemn Hamas. So I want to simplify this and see if we can get a response to you. Because, see, I think your approach and what you believe about things is important. It's important to Tennesseans. This is a life appointment. So knowing how people approach problem solving and approach issues is vitally important. And your answers were really quite troubling to me because it was a non-answer. And we would like something. So Do you think that ALDEF needs to release a statement strongly condemning the actions of Hamas, this beheading of babies, this raping of women, this putting babies in an oven? Yes or no? Should they release a statement? Yes or no?
Senator, I don't know anything about the statement.
Okay, let's see. So you have not watched the news lately. Let's move on. Do you believe that Hamas is solely to blame for this unconscionable violence in Israel?
Senator, I tried to respond to Senator Hall.
So that was a yes or no. So you don't have, see, this is what is of concern to me. Let's go at it this way. So do you believe this is a both sides issue? In other words, do you believe that both Hamas and Israel are to blame on this? Yes or no?
Senator, I don't believe it's a yes or no answer for me. It's a very complicated issue. It's a very tragic situation.
I think that the U.S. recognizes Hamas as a terrorist organization. This ought not to be complicated. I yield.
understand
Thank you,
that,
Mr.
Senator.
Chair.
Judge Keel, do you want to finish your answer?
I did, Senator. Yes, I understand that Hamas is considered a terrorist organization by the United States government.
Thank you. Senator Hirono?
Thank you, Mr. Chairman. I have to say that those questions relating to Hamas, et cetera, they're rather mystifying. This is not the Foreign Relations Committee, but be that as it may. I asked the following initial questions of all nominees on any of the committees on which I sit, so I will ask these two questions of our panel. And by the way, welcome to each of you and congratulations on your nominations. So, since you became a legal adult, have you ever made unwanted requests for sexual favors or committed any verbal or physical harassment or assault of a sexual nature? Judge Keel, let's start with you and we just go down the line.
No, Senator.
No, Senator.
No, Senator.
Have you ever faced discipline or entered into a settlement related to this kind of conduct?
I have not, Senator.
No, Senator.
No, Senator.
I have a short question for Mr. Fanzoni. You mentioned that that the best practices for OLC, you noted three things: frank and independent advice. I think your second was that this advice would be discussed, thoroughly vetted, and then the third is that the advice would be made public. So, are these three aspects, best practices, being followed by OLC right now?
Senator, it's my understanding, and based on conversations I've had with the prior leader of OLC, that they do follow these best practices now.
Do you know when they started following these best practices?
I think they've been best practices for some time, and obviously they're ideals, and there may be times when people think that they don't, but I think the goal is always to follow those best practices.
That would be good, because I would not think that the torture memo was one that was the best kind of legal advice. Question for Judge Keel. I want to welcome your mother, because, where is she, by the way? Can you wave? Hi. 안녕하세요. So, you noted that her naturalization papers are in your office?
They're hanging with my father's naturalization certificate at the entrance to my chambers.
Aren't you also naturalized?
I was naturalized, but through my parents' naturalization. I was too young at the time.
Oh, okay. So you don't have a naturalization document hanging?
I do have a naturalization. Okay. I don't believe it's called a certificate. It's some other document that I have. It has my picture on it when I was a very young child.
Well, I can relate to that because I have my naturalization document hanging in my office too. So it is a very important experience. Yes. To not come to this country speaking any English or any of that. And to see you here, it's a proud moment for your family. Ms. Russell, you spent some time at the beginning of your career working in the Office of the Public Defender. And public defenders play a vital role in the justice system, as my colleague Peter Welch always notes, that is a really important experience for people who are going to be judges. So can you speak to the importance of having strong prosecutors and defense attorneys in our adversarial justice system?
So, Senator, I did have the opportunity following my clerkships to work at the Office of the Federal Public Defender in Connecticut. It was a great opportunity to learn my way around federal court, often appearing in different proceedings before the court and representing clients. I do think it's an important role in our system. So there's the Sixth Amendment guarantee of the right to counsel to everyone in the country, regardless of the nature of the offense. Serving that seeing that constitutional obligation carried out through the work of the office was rewarding, and I think gave me experience that would be helpful in a transition to a new role as a judge, were I so fortunate to be confirmed.
I note in your background that you've led or are leading a number of clinical programs at your law school. So is there a high percentage of the students at your law school who sign up for these clinical programs?
There are. Quinnipiac has a great experiential program, so we have most of our students taking either a clinic or an externship, and this is a great opportunity for the students to learn while they're in law school and go into practice already knowing some of the skills they need to know.
I have to say that the clinical program that I was in was one of my best experiences at the law school. For Judge Keel, can you talk a little bit about the importance of diversity on our bench?
Yes, Senator. Diversity, from my perspective, works two ways. First is the outward view of the court. It instills confidence in our judiciary when the public sees faces like theirs within the judiciary. I think that also instills confidence in the public that there's other people, judges that have had those life experiences as well. I think it also works inward because we have a very small number of people in chambers. I've been very fortunate to have a very diverse group of law clerks, interns, and staff members. We have great discussions and hearing different viewpoints and hearing different lived experiences certainly, I believe, helps me to be a better judge.
I agree with you. Thank you, Mr. Chairman.
Thank you, Senator Rona. Before recognizing Senator Kennedy, I want to acknowledge Judge McCasey's arrival. We're glad to have you back in the room. And Professor French has already told us about your travails in arriving here, but thank you very much for coming. Senator Kennedy.
Thank you, Mr. Chairman. I just feel like I need to ask this question. Mr. Fonzone, when you advised the companies referenced, Huawei and others, you were at Sidley?
Yes, that's right, sir.
And when a client comes to Sidley, you have to fill out a form that says, here's my client name, here's my mailing address for business purposes, and here are my political beliefs. Is that the way it works?
There's definitely a client intake process. I don't remember all the particulars of it.
I mean, big law it's kind of like who can pay the freight, right?
That's an aspect of the intake process, I'm sure.
I understand. Professor, I'm looking at a letter dated March 16, 2020. It's a letter to Governor Lamont in Connecticut. The title of it is Urgent Action Needed to Protect Individuals in Connecticut's Prisons and Jails from Coronavirus 19 Pandemic. Did you sign that letter?
So I don't recall sitting here today, Senator.
Here's your signature. Here is back here. Why didn't you turn this over to us when you were asked to submit documents?
So, Senator, I made every effort to search for everything that I had ever signed. That's not a letter I remember, but I will certainly take a look at that. And
well, we found it just with a search on the internet.
So I apologize, Senator. I apologize.
In your letter to the governor, here's what you say. As they stand, prisons and jails are detrimental to public health and human rights and disproportionately harm marginalized communities. including black, brown, indigenous, and other communities of color, immigrants, people with mental illness, people with disabilities, people in the LGBTQ plus community, people who use drugs, people engaged in sex work and street economies, and people experiencing houselessness and poverty. So if you believe that about our prisons, how are you going to ever sentence somebody to prison?
So, Senator, I will need to take a look at that letter, and I apologize that that's not something I found to hand to this committee.
You're not denying you said that.
I do need to see the letter to see the context, because again, it's not something I remember adding my name to. I can assure you, right. Senator.
And you also say, first, you call on Governor Lamont to release everybody in jail. Is that right? Because of the coronavirus?
So again, Senator, I would need to see that letter in front of me. It certainly was not.
You can find it with, just put your name into Google. You'll find it in about 3 nanoseconds.
I will, Senator. I can assure you that
You said in your letter, Professor, we call on Governor Lamont, state of Connecticut, and all Connecticut jurisdictions to immediate release to the maximum extent possible people incarcerated pre-trial and post-conviction. And then you go on to say, talking once again about our jails, the global COVID-19 pandemic is throwing into sharp relief the untenable state of our penal system and the need for sustained action to shrink it. Shrink its scale, shrink its size, and shrink its scope. You sound here like the district attorney in San Francisco. If you believe that, how are you going to ever sentence anybody to jail, Professor?
I can assure you, Senator, that I understand the role of the judge, and that I can assure you prison time is an appropriate sentence in many cases.
That's not what you say here to the governor. You wrote the governor. This isn't some DoorDash delivery guy. You wrote the governor of your state 3 years ago.
So again, Senator,
in law school.
So again, Senator, I would need to look at the letter. It sounds like it was written at the height of the pandemic, where governors were looking for.
You also wrote the governor, you said people over the age of 55 are at the greatest risk for COVID-19, but also pose the least public safety risk to our communities. People in this age group can and should be released immediately to mitigate the spread of COVID-19. You think the governor just, if you're over age of 55, he should let everybody go?
No, Senator, that's not a position.
That's what you said.
Okay.
Here it is, biggest house.
Again, Senator, I will look at that letter. I can assure you that.
Find it on Google, Professor. You also say Governor Lamont should issue an executive order to direct the state's attorney offices and law enforcement entities, including the town and city police departments, and any federal law enforcement entity operating within the state to immediately cease adding to the incarcerated prison population given the high risk of infection posed by the population increase. You asked the governors to tell every law enforcement official in the state to stop arresting people and putting them in jail, didn't you?
So again, Senator, I have to look at that letter. I do think there were modifications that the governors were making around the country to respond to the pandemic.
You also had an opinion in your letter about, can I have another 30 seconds, Mr. You had an opinion in your letter about immigration. You said immigration detention poses the same health risk to jails and prisons, and Connecticut law enforcement must stop feeding people into the unsafe and inhumane immigration detention system. Then you say Governor Lamont should release all individuals currently in state custody who are awaiting transfer to ICE custody, and the governor should declare a moratorium on all such future transfers. How, if somebody is in our country illegally and commits a crime, are you going to put them in jail if you believe this about immigration?
Senator, I can assure you, were I so fortunate to be confirmed, I would treat crimes seriously.
That's not what this letter says, Professor, and it was 3 years ago. It wasn't when you were in law school, and you didn't turn it over to us. We had to find it on our own.
Senator, the chair has been generous in time. I think you've had your opportunity. Would you like to complete your sentence or statements?
Thank you, Senator.
I didn't mean to cut you off, but Dick was going to cut me off, so
I understand. And I apologize. I made every effort to find anything that I had been associated with. There were many emails and internet searches and otherwise that I did. I apologize if this is something I missed. It sounds like it was a letter that many people signed on to it. I will certainly review that and supplement my submissions to the committee. So I apologize, Senator, for having missed that.
Let me suggest that you get a copy of the letter and respond for the record in writing as to what the nature of the letter was and what your position was. And let me also add, it was under the Trump administration where we made decisions here that the Federal Bureau of Prisons would release at least under supervision thousands of inmates because of the worry over the public health crisis which we faced. Senator Booker.
I would not only say that during the Trump administration that we did compassionate release, and I was grateful to work with the Trump administration on that, but Republican governors and Democratic governors all across the country focused on people that presented the least amount of risk, people that were medically vulnerable, no violent sexual terroristic related convictions, the completion of a substantial amount of their sentences. So this was not unheard of, and there were people advocating for that all over the country. Again, Democrats and Republicans felt that that was the right thing to do. And then just, Professor Russell, I'm sorry. I know you said your family is here, but is that them in the second row back there, and those are your three boys?
That's right, Senator.
Yeah, well, I just want you to know they have an obnoxious amount of hair. And I feel a little frustrated by that. It's good to see your family here, and it's grateful that your willingness to serve. Judge Keel, thank you very much for being here. I just want to clarify a couple of things, because clearly you condemn hate crimes, whether it's hate against African Americans, hate against Jewish Americans, hate against Asian Americans, something you condemn. There's no controversy here.
That's correct, Senator.
And then it is to put you in an uncomfortable position to ask you to speculate about statements by any group in America, being that issues of the First Amendment and freedom of speech could potentially come before you as a judge, correct?
Correct, Senator. And also, as I said, I know nothing about the statement itself. I haven't been involved with the organization for a very long time.
Yeah, more than a decade. And any organization, you have to deal with cases and controversy, and sometimes they're very difficult issues. What's happening on our college campuses, which I have been following, is awful and difficult. But I imagine there'll be a lot of cases that are going to be coming out of those current conflicts, and it would be inappropriate for you to comment deeper on these issues of matters that might come before you. Is that correct?
That's correct, Senator.
Yeah, I'm greatly appreciative of that. The truth of the matter is, on a personal level, your personal feelings, as we have seen hate crimes rise, I'm sure you have deep personal feelings as we've seen attacks on Asian Americans increase, as we've seen Muslim, anti-Semitic comments. I'm sure you have deep personal feelings on that increase of hate crimes in America, correct?
Yes, Senator.
But regardless of your personal feelings, they definitely don't affect your role as a judge, correct?
It would not, Senator.
Exactly.
And it has not.
Of course not. Of course not. I know the dignity you bring to the job that you do, and I know the independence you bring, and the sober nature with which you examine the matters that come before you, and I'm deeply appreciative of that. Mr. Fonzone, right? Am I pronouncing that right?
That's correct, Senator.
Thank you very much. The Boston Massacre. Are you familiar with that at all?
Yes.
You are.
Yeah.
Who represented the British?
I believe it was John Adams.
Yeah, you're pretty good with your American history. I'm very impressed. I was trying to make you stumble, sir. You passed. I won't ask you to do any complex long math, but clearly you graduated high school history. So an American founding father represented British who massacred early colonists. Is that correct?
That's correct, Senator.
Should we cast any aspersions on the patriotism of someone who represented British?
As one of our presidents, I don't think we should cast aspersions on John Adams.
I really appreciate that. I am a member of the, not a member of, but I have supported the ACLU in the state of New Jersey a lot. Their history has been representing people that I would consider despicable, who have despicable views. Is that correct? Did the ACLU?
Yes, they've definitely represented folks who have despicable views.
Yes, and should I ascribe any of the views of the clients that you've had in your life, should I ascribe them to any of your personal feelings?
No, Senator.
Okay, I appreciate that. Thank you very much. And the last thing to Judge Keel, who I'm grateful for you being here, and the trailblazing nature of your position. Really, I mean, literally going to be, if confirmed, you're going to be the first Korean American judge on the District of New Jersey. You're aware of that?
Yes.
Yes. And so I guess my last question is, because I kind of got a feeling of your parents and your mom, it sounds like she was pretty tough. Is that true?
She was nicer than my father.
Okay. I'm just wondering, finally, do you think your mom is really proud of you?
I know that my mom is really proud of me, and I do thank the senators before for recognizing my mother, because my mother has been largely in the background, but she's worked incredibly hard, and I'm very happy that she got some recognition today.
It is a righteous thing that on the record in the United States Senate for in perpetuity will be how awesome your mother is.
Thank you, Senator.
I just want again, obviously you can see my insecurities. I just want to put on the record that your son too has obnoxious hair.
We tell him that all the time.
Okay.
Thank you.
Senator Cruz.
Thank you, Mr. Chairman. Professor Russell, I want to go back to this letter that Senator Kennedy was asking you about it. You signed this letter March 19th of 2020. That was 3 years ago. You did not disclose this letter to the committee. Why did you not disclose it to the committee?
So, Senator, I have no memory of signing that letter. It sounds like it was right at the start of the pandemic. So I apologize. I made every effort to try to find anything that was responsive
So I guess if
Senate.
you have no memory, you didn't consider it that big a deal, I'm assuming?
Senator, I'm just not sure. It's not something I remember signing. I don't doubt that,
All right,
that you
I
have
want
it
to
there.
talk about this letter because it's an extraordinary letter. This is not, I know the chairman and Senator Booker were trying to rehabilitate you by saying, well, lots of people did humanitarian release for some people incarcerated. That's true. But this letter is not within the bounds of the mainstream. This letter is actually quite extreme. This letter begins with the undersigned organizations and individuals call on Governor Lamont to act immediately to protect the lives of incarcerated people in our state. 3 urgent steps are needed: the immediate release of as many people in custody as possible, 2, a moratorium on new admissions into jails and prisons. Do you think a moratorium on new admissions into jails and prisons, is that a policy you support?
So, Senator, again, I don't have the letter in front of me to understand the context, but I know there were efforts to reduce new admissions, but there are obviously some people who would present a public safety risk.
But your letter didn't say that, and I want to read from this letter because it is an astonishing letter. The second page, we call upon Governor Lamont, the state of Connecticut, and all Connecticut jurisdictions to, 1, immediately release to the maximum extent possible people incarcerated pre-trial and post-conviction. We recognize that jails and prisons are not safe and do not promote well-being for anyone. The global COVID-19 pandemic is throwing into sharp relief the untenable size of our penal system and the need for sustained action to shrink its scale, size, and scope. This next sentence is underlined. We outline below a few considerations to initiate state action and emphasize they do not preclude the release of groups not explicitly discussed in this letter. Do you think it was a good idea to, as this letter says, quote, immediately release to the maximum extent possible people incarcerated pre-trial and post-conviction?
So, Senator, I'd want to understand the context around extent possible.
It's a letter you signed, so you know the context.
So again, Senator, I don't have it in front of me, and I didn't have a memory of the specifics. Releases need to be...
Give a witness a copy of the letter, which is right there. You'll have it in front of you in about 10 seconds.
Thank you, Senator. I do believe releases need to be consistent with public safety.
Okay, well, that's not what this letter says. The letter continues, pretrial release, quote, Governor Lamont should use his emergency powers to protect incarcerated people, their communities, and correctional staff by releasing all people, all, who are incarcerated without having been convicted of any crime. All people means murderers. It means serial rapists. It means child molesters. Do you think it is remotely reasonable to call upon the governor to release every murderer in the state of Connecticut prior to conviction to essentially eliminate pretrial incarceration?
So I think, Senator, that releases should be consistent with public safety.
But that's not what you said. The letter doesn't say that. It's all.
Were I so fortunate to be confirmed as a judge, I would strictly follow the Bail Reform Act, which includes preventative detention.
But that's not remotely this letter. All right, the next page. You also call on the governor to do this, and this is a quote, declare a moratorium on incarceration. Governor Lamont should issue an executive order to direct the state attorney's offices and law enforcement entities, including town and city police departments, and any federal law enforcement entity operating within the state to immediately cease adding to the incarcerated population given the high risk posed by population increase, both to those already incarcerated and to those entering correctional facilities. Public officials with authority to set bail, including judges, and you're nominated to be a judge, bail staff and police officers should maximize release on personal recognizance. Do you think it is a good idea to declare a moratorium on incarceration and to say in Connecticut, we are no longer arresting anybody? Because that's what your letter says.
So, Senator, as I heard it, it was urging a sort of to the extent possible, and I guess, you know, my view at that time with the pandemic is, and I know that the process...
It doesn't say to the extent possible. It says all. And let me ask you, you're a law professor. You signed a letter asking the governor of the state of Connecticut to issue an executive order ordering federal law enforcement to cease adding to the incarcerated population in the state. Is there any plausible constitutional justification for a governor ordering the feds, you are no longer allowed to incarcerate anyone in our state?
I would assume, Senator, that was a reference to using state facilities.
Say that.
So again, Senator, I think that this appears to be a letter that was
So lots of people signed something kooky, but lots of people haven't been nominated to be a judge. The last thing you say is you call on Connecticut to release illegal aliens and not refer them to ICE, to release them all. Is that a policy you support, releasing every illegal alien as well, in addition to releasing murderers and rapists and child molesters? Three years ago, you did not.
Senator Welch.
Thank you. I'll be brief. I know time is short. Just a couple of things. I'm delighted to have another public defender being nominated, and I thank Senator Hirono for bringing that up. And is it permissible to move that all of the entire families? It was wonderful to get the introduction of your families. You'll all be part of the judicial team after a vote, hopefully. I want to go to Senator Cruz. I know in Vermont we had a real debate. We have a Republican governor, Democratic legislature, so it was divided. But we were really struggling with what to do all around, but particularly with folks who were incarcerated because it was seen to be a very, very dangerous health situation, not only for the inmates, but for all the folks who work there. And there were significant adjustments that were made that in normal times, pre-COVID, would probably not have been made. And it did include early release of a number of people. There was always a focus, obviously, on making certain that people who were regarded as extremely dangerous would not be set loose. So whether everybody got it right, I don't know, but what I do know is that in Vermont we made significant accommodations, and I think our public health was benefited by it. And I also do want to say I think it's a fair debate about the prison system and whether our approach to justice is over-reliant, because we do have an extraordinarily high prison population, second only to Russia. So I think it's a fair question for people who are concerned about justice to take into account the question of whether there's alternatives or other ways to provide for public safety as opposed to just rely on prison. I mean, the 3 strikes laws that we had, the excessive, the differential sentencing for crack cocaine or powder cocaine, there's a whole array of things. So I just want to acknowledge that that is an ongoing debate. Mr. Fanzone, I thank you for your work. I just want to make sure that you'll continue the effort to try to have more transparency from that office. That's really important, I think, to all of us.
Yes, Senator. I think one of the I think best practices of the office is to be as transparent as it can be about its opinions, and I think that it has a presumption that its significant opinions would be made public. There's times when officials or agencies ask for advice and they ask for confidentiality, we have to respect that.
Right.
But in general, would be
thank you. And I'm just going to go down for each of you because if by the definition, if you're a lawyer, you're advocating for your client. So you're oftentimes advocating not necessarily for things that you believe in, but are legitimate arguments or legitimate positions on behalf of your client. But you play a different role as a judge. So I just want to allow you each to affirm that in your role as a judge, it will be your view of the law and the facts as opposed to your personal point of view that will be the basis upon which you make your decisions. Judge Kyle?
Yes, Senator, that's correct. I practiced in private practice for 28 years, and I was an advocate for 28 years.
Right.
And when I became a judge, I had to turn that off and keep an open mind for all.
And Professor Russell, I see you got some backup here with Mr. Mukasey. Thank you, but can you do that?
Yes, so Judge Mukasey was my first judicial role model and remains my role model. And so I think it's critical that judges approach their work with an open mind, setting aside any past experiences or personal views, and consider each case individually. Whenever I appear before court, that's the kind of judge I wanted for my clients, and that's the kind of judge I would want to be.
Mr. Fanzo?
Yeah, thanks, Senator. If I was fortunate enough to be confirmed at the Office of Legal Counsel, my North Star would be delivering frank and independent advice free of my preferences or the policy preferences of the administration.
I yield back.
Thank you, Senator Welch, and thanks to all the nominees. Just a logistical note, if you receive written questions, if you could have them back to us by the end of business on November 8th, I'd appreciate that. Thank you, your family and friends, for this appearance before the committee.